mentioned, my name. Now we can officially get started. My name is Judge DiPolito. Scoring judges, please look to the two buttons on the lower left of your screen and turn off your audio and video. These should remain off until trial ends. You should also have your video set to hide all non-video participants, which means the only people on your screen right now should be the advocates and me. And with that, can the attorneys please make appearances, starting with the government?
Yes. Good evening, Your Honor, members of the jury and opposing counsel. My name is Paul Atherton, and today, alongside my second chair, Ms. Gabriella Rao, we will be representing the prosecution throughout today's trial.
Good afternoon, Mr. Atherton. Defense?
Good afternoon, Your Honor. My name is Getachew, and I, along with my second chair, Skylar Walker.
Good afternoon, Your Honor.
We represent the defendant in today's case, Ms. Kara Bassett.
Good afternoon, Ms. Getachew. Are there any preliminary matters before we start with opening statements?
Yes, Your Honor.
Yes, Your Honor. The prosecution does as well.
All right, we'll start with the prosecution first.
First, Your Honor, we would direct the court's attention to pretrial order 7, evidentiary ruling 1, which identifies that exhibits 4 through 33 are pre-admitted.
Okay, defense counsel, do you agree with that interpretation of the order?
Yes, Your Honor.
All right, great. Anything else?
Yes, Your Honor. Next, we would direct the court's attention to pretrial order 13, stipulation 3, which identifies that all the exhibits for this trial are deemed authentic prior to trial.
Defense, do you agree with that categorization?
Yes, Your Honor.
All right, great.
Finally, Your Honor, we would like to invoke Rule 615, the constructive sequestration of witness.
All right, will you constructively have a party representative today?
No, Your Honor.
All right, great. Defense, will you have a party representative today?
Yes, Your Honor. While the defendant is not testifying in court today, Ms. Bassett is our party representative. She is present in court.
Great. So all the other witnesses can constructively leave, and we will call you to the stand when we need you. Anything else?
Not on behalf of the prosecution, Your Honor.
All right, great. Defense, anything before we start with opening statements?
Yes, Your Honor. While exhibits 4 through 33 have been pre-admitted, there are some exhibits that haven't been pre-admitted and need to be entered in court today. Since this is a trial on Zoom, we can't show witnesses' exhibits on Zoom without also showing it to the jury before that exhibit's been entered. Our plan was to ask witnesses to pull up the exhibit on their own in order to ask questions about authentication. Is it all right then if we ask that witnesses keep a copy on hand of the Gladiator case?
Yes, that's fine with me. Prosecution, do you have any issue with that procedure?
No objection, Your Honor.
All right, great. That's how we'll do it then.
In addition, Your Honor, due to the unusual nature of doing a trial over Zoom, it's also difficult or impossible to show opposing counsel an exhibit without also showing it to the jury. In that case, is it all right if I and Mr. Atherton agree that we all have a copy of the case and we don't need to show each other additional exhibit copies if we want to enter something into evidence? That's
fine. Just please, for the record, state which exhibits you're referring to during your examination so opposing counsel has a heads up. That's fine.
In addition, we'd like the court to take notice of Rule 603 and assume that all witnesses have been pre-sworn.
Yep, 603 is invoked.
With that, Your Honor, the defense is ready to proceed with opening statements.
All right, great. So we will start with the government whenever you're ready.
Yes, Your Honor. Just a moment. She chose her passions over her partnerships. Members of the jury, you are going to hear a lot throughout today's case. Today you're going to hear about Kara Bassett. Kara Bassett had a business partnership with Don Clark. She also had a life partnership with Don Clark. And yet, she killed her life partner. The two had a business partnership in owning the Greater Tallahassee Elephant Park, which opened in 2011. They ran the business phenomenally. However, because the defendant could not obtain full control over the business, she became discontent. The partnership deteriorated, which led to the events of August 18, 2017. As the proof will show, the defendant stabbed her husband with a tranquilizer by the name of carfentanil, a mere tranquilizer for elephants, but a deadly drug for humans. Following this, she put Don Clark in her Chevrolet Express van, drove him to the Big Gum Swamp, took him out of the van via wheelchair, and dumped him in the swamp, knowing that it was infested with alligators. Now, knowing it takes these beasts just days to consume and digest a human body, what did the defendant do? She waited 7 days to alert the police of the disappearance of her life partner. And this is why we have charged the defendant with murder. We're the prosecution, which means that we have the burden of proof. We have to prove to you beyond a reasonable doubt 2 things. 1, that Cara Bassett killed Don Clark. And 2, that she did so with malice aforethought. Today we will build our case piece by piece, exhibit by exhibit, testimony by testimony, until you are left with an overwhelming tower of circumstantial evidence. For clarification, we do not have to provide an eyewitness of the scene. Rather, we must only show to you, by utilizing circumstantial evidence, the events transpired as we proved them. Today you'll hear from 2 witnesses, the first of which will be Agent Braun. Agent Braun will leave you conclusively convinced that the murdering of Don Clark originated at the hands of his own life partner. You'll then hear from Joe Young, who will identify the fact that she heard the defendant say that she would take someone to their graves to protect her own. But as I mentioned before, the defendant chose her passions, her elephants, over her partnerships, which included not only a business partnership, but a life partnership with Don Clark. But before I end, I'd actually like to challenge the defense. I'd like to challenge this Getachew to present just one witness that can identify they saw Don Clark following the night of August 18, 2017. But they will not. Because they cannot. And they cannot because the final creature to have seen Don Clark had scaly eyes and over 80 razor-sharp teeth. We ask that you find the defendant guilty. Thank you.
Thank you, counsel. Defense, are you ready to give your opening statement?
Yes, Your Honor.
All right, great. Whenever you're ready, you may proceed.
May it please the court, the members of the jury. The government overlooked the truth. The woman in this photo is Cara Bassett. She's the person who's on trial today. You'll learn that Miss Bassett manages the Greater Tallahassee Elephant Park. You'll learn today that she didn't always work alone. For 6 years, she managed this elephant park with her husband, Don Clark. Now, Mr. Atherton just got up here and told you that Miss Bassett chose her passions over her park. While it's true that Miss Bassett was very passionate about animals, you'll also hear in court today that she was passionate about Don Clark. They lived happily together until August 18th, 2017. The last day Miss Bassett would ever see her husband again. Cara Bassett had to face a truth too painful to imagine. Someone she had loved dearly had gone missing. But you'll learn that instead of investigating for the truth, the government placed all of their suspicions onto Miss Bassett. A year later, Cara Bassett had to face another truth too painful to imagine. She'd been arrested for a crime that she didn't commit. She'd been arrested for her own husband's murder because the government overlooked the truth. But we're here in court today because the government charged Cara Bassett with murder, meaning they hold the burden of proof in today's case. Members of the jury, in court today, Ms. Bassett has what's called a presumption of innocence. This presumption is the very foundation of our legal system, because in our country, All defendants are innocent until proven guilty. Miss Bassett is innocent today until the government has proven beyond all reasonable doubt that she killed Dawn Clark and that she intended to kill her. This is the highest burden of our legal system. To meet this burden, the government can't leave any questions unanswered. They can't leave any holes in their case, and they can't leave a single stone unturned. And they won't meet this burden in court today, because the evidence will show you that the government overlooked the truth. Let's talk about what the government overlooked. You'll hear in court today from Joe Young, a TV producer who worked with Miss Bassett and Dawn Clark every day for 3 years. He'll tell you that Dawn Clark had some suspicious and secretive business dealings in Costa Rica. You'll see Dawn Clark's phone records today. You'll see that just hours before he disappeared, a Costa Rican number called him, and they spoke for nearly an hour. But Agent Branham will tell you on the stand today, the FBI have never found out who this person was or why they were calling, because the government overlooked the truth. Members of the jury, I want you to pay close attention to what the government won't show you in court today. You won't see a body. You won't see an autopsy. You won't see any physical evidence that directly links Miss Bassett to this crime. In fact, you'll learn that the government wasn't able to find a single person to back up Agent Brandon's theory of what happened, because the government overlooked truth. Which is why at the end of this trial, I'll come before you again and ask that you find Care Bassett not guilty. Thank you.
Thank you, counsel. Okay, so before the government calls its first witness, I'll ask everyone now to switch to gallery view. That button's located in the upper right of your screen, and this will allow you to see the attorneys and the witnesses at the same time during examinations. With that, is it Mr. Atherton or Atherton?
Atherton, Your Honor.
Atherton. Mr. Atherton, if you'd like to start your case in chief and call your first witness, you may do so now.
Yes, Your Honor. The prosecution calls Agent Steph Branham to the stand.
All right.
May I proceed?
Yes, you may.
Please state your name for the benefit of the court.
Hello, I'm Agent Steph Branham.
What do you do for a living, Agent?
Currently, I'm a senior special agent with the FBI.
Let's talk about your background. Please elaborate on your experience in that field.
Certainly. So I started working as an FBI agent back in 2002. Prior to that, I'd received a degree from the University of Cincinnati in psychology. And since 2002, I've worked in different capacities at the FBI. All entirely, I've worked in the Criminal Investigations Division for 18 years.
Now, in your role in the FBI, what sort of cases have you dealt with?
I've dealt with violent crimes, anywhere ranging between trafficking, kidnapping, murder, all sorts of things such as that.
Your Honor, at this time, the prosecution tenders Agent Branham as an expert in the field of criminal investigation.
Any objection?
Yes, Your Honor. The defense objects under Rule 702. This witness does not need to give any expert testimony in court today. May I be heard?
Yes.
There is no opinion or testimony this witness is going to elicit in court today that is based on any scientific, technical, or otherwise specialized knowledge. There is no testimony this witness is going to give that is an expert opinion. Your Honor, this witness can testify to the steps of his investigation and the evidence that led him to the conclusion to arrest Miss Bassett. But this isn't based on any scientific, technical, or otherwise specialized knowledge. And tendering him as an expert is not going to assist the trier of fact in determining a fact of issue.
Response? Yes.
Yes. My response falls under two rules. The first, we would direct the court's attention to Rule 702, which identifies the fact that in order for an expert to be tendered as such, they must fulfill just one of the 5 criteria, which are skill, knowledge, experience, education, and training. Based upon the evidence that we have just provided, Agent Branham has the skill, the knowledge, the expertise, the education, and most definitely the training, Your Honor, and therefore he is most certainly allowed to be tendered as an expert. In addition, I'd like to address opposing counsel's second point that it will not assist the members of the jury in understanding the case at hand. Your Honor, in all candor, the prosecution could not contest that point enough. Under Rule 703, in order for an expert's opinion to be relevant and in order for an expert's opinion to apply to a case, it must not simply assist, but substantially assist the members of the jury in understanding the case. And Your Honor, under Rule 104B, we would most certainly, if need be, conditionally admit this expert as such. However, Your Honor, we do not believe that is necessary, as we have laid the proper foundation.
Your Honor, may I respond?
Please.
Under Rule 702, opposing counsel has to lay more evidence for more than one prong under Rule 702. This witness's opinion in court today has to be based on any scientific, technical, or otherwise specialized knowledge. Now, just because a witness may have some knowledge or some skills doesn't mean they should be tendered as an expert. That would add unfair weight and credibility to their testimony. This witness has no forensics training. There is nothing he's going to testify to that is based on any science or technical or specialized knowledge. This witness can testify to the steps of his investigation and lead him to a conclusion. And that opinion could be given as a lay witness under Rule 701. Under Rule 702, this witness's opinion in court today does not meet the qualifications to be tendered as an expert.
Counsel, you mentioned that there were some other prongs of 702 that have not been satisfied. What prongs are those?
Well, first, the expert's knowledge has to be based on scientific, technical, or otherwise specialized knowledge. And the opinion he gives has to help the trier of fact in making the fact at issue. It has to be based on reliable principles and methods, sufficient facts and data, and has to be fairly applied to the principles and methods of the case. Your Honor, none of what this witness is going to say in court today is scientific or technical. All this witness is going to testify to is the evidence he collected and what conclusion that led him to. That is a rationally based conclusion that can be given as a lay witness.
May I respond, Your Honor?
Please do.
First, we would direct the court's attention to Gladiator Rule of Procedure 2, Section E, subsection 2, which identifies the fact that experts cannot provide expert opinions unless they are tendered as such. Moreover, Your Honor, we are tendering this witness before he can provide an opinion, because that are the rules of the competition. Additionally, to opposing counsel's point that we have yet to fulfill the 5 prongs, Your Honor, we have most certainly fulfilled the 5 prongs.
May I respond, Your Honor?
Not yet. Mr. Atherton, how have you satisfied the other prongs of 702? Specifically, I'm referring to sufficient facts and data, reliable principles and method, proper application of those principles and methods to the facts. I'm inclined to agree with defense counsel in that a law enforcement officer or agent, it's highly unorthodox for an individual of this sort to be tendered as an expert witness because they're not applying any such principles or methods that are reasonably relied upon. Can you please elaborate on your argument there?
Absolutely, Your Honor. The prosecution would respectfully disagree. The prosecution is tendering Agent Branham as an expert in the field of criminal investigation. Agent Branham investigated the entirety of the situation behind August 18th on August 25th. Therefore, he can most certainly provide an opinion based upon exactly the evidence that he was provided. However, Your Honor, if need be, I'd be more than happy to lay additional foundation.
Sure. Why don't you try to lay more foundation as to 702? At this point, I am inclined to agree with the defense. I don't believe that the 702 prongs have been satisfied. At the same time, I'm not sure if it's all that necessary for this witness to be tendered as an expert to help the jury as the finders of fact. But I'll allow you to lay more foundation if you want to.
Thank you, Your Honor.
So I'll conditionally sustain the objection.
Yes,
Thank
Your
you, Your Honor. Agent, based upon the experience in which you have obtained within the FBI, did you apply your experience within your conclusion regarding the night of August 18th?
I certainly did, yes.
Once again, Your Honor, the prosecution tenders Agent Branham as an expert in the field of investigation, specifically criminal investigation.
Your Honor, I'd like to renew my objection under Rule 702. I don't believe any of the foundation for the prongs under Rule 702 has been fulfilled. This witness does not have any scientific, technical, or otherwise specialized knowledge that he's going to use for an expert opinion in court today. The only opinion this witness is going to offer is that based on the steps of his investigation and the evidence he collected, he believed Ms. Bassett was responsible. And that's an opinion that a lay witness can give under Rule 701.
May I be heard once more, Your Honor?
Yes.
Opposing counsel just made a fantastic point. She identified the fact that experts can provide opinions based upon reasonable evidence and data that they have been provided. Moreover, Your Honor, we have most certainly laid the foundation that Agent Branham will continue to testify regarding his opinion regarding the night of August 18th based upon the evidence that he has been provided, which included his investigation of the crime scene, which is why we are tendering him as such.
I'm still inclined to agree with the defense on this one. I'm going to sustain the objection. I do believe you'll be able to direct this agent without having to tender them as an expert or rely on 702 to provide those opinions. The objection sustained.
Yes, Your Honor.
Agent Branham, are you aware of the defendant in today's case?
Yes, I am. I interviewed the defendant, Cara Bassett, on several different occasions.
Did you conduct an investigation based upon August 18th?
Yes, I did. We were contacted on August 25th of 2017 by the defendant, and at that point we started an investigation into her husband's disappearance from August 18th.
I apologize, Agent. I believe the audio may have disrupted what you said. But for clarification for the members of the jury, did you mention that Cara Bassett noted that Don Clark disappeared the 18th of August?
Yes, sorry. I testified that Cara Bassett had called me on the 25th of August and that he'd gone missing on the 18th. So it'd been an entire week when she reported it.
All right. Well, what, if anything, did you do following this phone call?
Following that phone call, we went to the elephant park that Cara Bassett and her husband lived at, and we searched the premises.
When, if ever, did you discover anything that was odd throughout the premises?
We searched a shed in which a substance known as carfentanil, an elephant tranquilizer, was kept, and we found a logbook that was interesting to us in our investigation.
Would you be able to recognize that logbook?
Yes, I would.
Your Honor, the prosecution would like to show an image of one of the exhibits, specifically Exhibit 29.
Okay, I believe that's already been admitted into evidence, so feel free to, counsel.
Agent, what exactly did you find to be odd in relation to this exhibit?
What was odd about this exhibit was the very last entry. It says that on August 1st of 2017, there were 24 syringes of that carfentanil. However, during my investigation, we only found 23 syringes at the elephant park. One was missing.
Now, for clarification, Agent, did you examine any additional documents?
I did. I also examined a legal document known as a power of attorney document. That was Don Clark's.
Would you be able to recognize that?
I would, yes.
Let the record reflect that Ms. Rowell will be showing an image of Exhibit 15. Is this what you were referring to, Agent?
Yes, sir, it is.
Now, what exactly did you find odd about this?
Specifically, what was odd about this exhibit was the disappearance clause that is highlighted, section number 2. But what that said was that if Mr. Clark were to disappear, Ms. Bassett would get control of his assets, including that elephant park and around $1.9 million of the property and different money that he owned.
Now, Agent, have you ever noticed a disappearance clause within a power of attorney?
I can't say that I have in my line of work, but we also received a letter from Mr. Clark's attorney that said she'd never written one. They're very unusual.
Now, based upon the evidence that you have gathered, are you aware of the clause to which Cara Bassett was abiding by?
Yes, when the defendant enacted this power of attorney agreement, she was referring to the second clause, that disappearance clause.
Thank you, Agent. That is all for now. Now, Agent, for clarification, what exactly did you do next within your investigation?
After that, we followed some GPS records that we had uncovered in our investigation for a van that was kept on the Elephant Park property, and we later found that at the Carrie Belleone Airport.
When, if ever, did you discover a plane at the airport as well that was Don Clark's?
We also found a plane at that airport that belonged to Mr. Clark. That's correct. What was interesting about that was that it was still parked at the airport, meaning that Mr. Clark presumptuously hadn't gone anywhere.
Would you be able to recognize that van if it were shown to you?
Yes, I would be able to recognize the van.
What exactly did you discover within this examination?
We found a few things within that van. First, there were 6 of Mr. Clark's hairs in the back side of that van. We also found some algae on the gas pedal, the brake pedal, and the driver's side floor mat. And then there were fingerprints from a worker at the Elephant Park, Kelsey Stebbins, who used the car for work purposes, and also the defendant and Mr. Clark.
Now, were you able to decipher where exactly the algae found on the foot pedals originated from?
We were. We had a forensics lab test that algae, and it matched to algae found at a Florida swamp known as the Big Gum Swamp.
Now, because the foot pedals were at the foot area of the car, does that mean that somebody's feet were on it?
Well, yes, sir. We believe that because we found algae on the defendant's boots, the algae had transferred from the Big Gum Swamp to her boots to those pedals.
Would you be able to recognize those boots?
I certainly would, yes.
Is this what you were referring to?
Yes, sir. Those are the defendant's boots.
Now, for clarification, where exactly did you discover that the dirty substance at the bottom of the boots originate from?
We found that that had come from the Big Gum Swamp.
All right. Now, did you individually examine the Big Gum Swamp?
I did. I later went there in my investigation to search for any trace of Mr. Clark and then to test that algae as well.
And did you discover any blatant indications of violence?
We did not. We searched the area with trained dogs, but they weren't able to find anything. However, what has to be kept in mind is that this is a Florida swamp, and so there are certainly alligators that are around. We believe that it's possible an alligator could have consumed the body of Mr. Clark in that week period.
Now, Agent, for clarification, did you ever have a one-on-one conversation with the defendant?
I did, yes.
And based purely upon your observations, how did she appear to be acting?
The defendant appeared to be acting strange, I would say. She didn't seem very upset about the loss of her husband. What she was more concerned about, what she was very passionate about, I would say, was that Elephant Park. That's what she kept talking about.
All right. Now, once again, Agent, did you discover any additional documents relating to the disappearance of Don Clark?
I did. I found a report relating to domestic violence that Mr. Clark had filed.
Would you be able to recognize that?
Of course.
All right. Before we provide it into the screen, Your Honor, the prosecution would like to enter Exhibit 34 into evidence, as its authenticity has been stipulated.
Any objection?
Yes, Your Honor. The defense would object to hearsay under Rule 801 and improper character evidence under Rule 404B. Your Honor, would you like for me to go through the hearsay or the character evidence objection first?
Let's start with the character evidence, and if we could get the exhibit onto the screen and constructively jurors pretend you can't see it.
Yes, Your Honor.
Okay, let's first hear the character evidence-based objection.
Yes, Your Honor. The prosecution is offering evidence that Ms. Bassett may or may not have been violent towards Don Clark in the past or threatening towards Don Clark to prove that on August 18th, 2017, she was violent towards Don Clark when she killed him. Therefore, they are using this evidence to prove conduct in conformity with the prior bad act. Therefore, this is improper character evidence under Rule 404B.
Response?
Yes, Your Honor. This falls under Rule 405, Section B, as it identifies that in the event a person's character trait is an essential element of a certain charge or claim, it is most certainly admissible in the event it is in reference to a specific instance of conduct. If we could direct the court's attention to the bottom section, which identifies all of the criteria, or rather of the boxes that Don Clark indicated, those most certainly pertain and rather fall under Rule 405B. May I address opposing counsel's hearsay objection?
No, we have not satisfied the character evidence. In response to that, counsel, or I'll let the government respond to that response first. Then I'll address the character evidence further.
Pardon me. To hearsay, Your Honor?
I'm sorry, the defense. Any response to the government's response regarding 405?
Yes, Your Honor. I believe the portion of 404B Mr. Atherton is referring to is the section that lists out other uses of character evidence. This clause doesn't say that character evidence is admissible in these circumstances, but rather some instances they can use evidence to show something else. However,
I don't mean to interrupt, but I believe the response pertained to 405B, claiming that it was an essential element of the claim. Am I correct in interpreting that, Mr. Atherton?
Yes, Your Honor.
Okay, so with respect to 405B, not 404B, I don't believe we've heard a response to that.
Yes, Your Honor. In that case, I'd like to respond to Mr. Atherton's use of 405B. Rule 405B, A, and B are not exceptions to the rule of character evidence. Rather, if character evidence is decided to be admissible, Rule 405A and B list out ways to show that character evidence. Under Rule 405B, it is not an exception to character evidence if someone's character is an essential element of a claim or a charge. Rather, if Your Honor were to decide that this was admissible character evidence, then Mr. Atherton could use the methods outlined in 405A and B to show evidence of that character.
May I respond to that, Your Honor, or the hearsay exception, or rather hearsay objection?
So we're still on the character issue. I tend to agree with the defense's interpretation of 405 in that it demonstrates how you can present character evidence once the 404 hurdle has been cleared. So we still have to figure out what's going on with 404. With respect to these acts being essential elements of the charge, certainly past character is not an essential element to murder. Typically, we see that kind of exception pertain to things like defamation, where someone's character is an essential element. For something like murder, that would not apply. Notwithstanding that, let's talk about 404, though. Response to the defense's argument there?
Yes, Your Honor. Additionally, as I identified before, this does fall under 405B, but in addition to that, this also falls under Rule 608, Section B, as it goes towards the truthfulness, or in this case, the lack thereof, of Cara Bassett.
How so?
Your Honor, the defense, or rather the prosecution, would contest that Cara Bassett denies these claims. Therefore, it most certainly goes to her lack of trustworthiness.
Response to that?
Yes, Your Honor. Nowhere in this document does it say anything about Ms. Bassett's character for truthfulness. Opposing counsel is only using this document to show action and conformity therewith. That because Ms. Bassett may have been violent towards Don Clark in the past, that she was violent towards Don Clark on the day in question. There is nothing in this document that says anything about Ms. Bassett's truthfulness. Therefore, this cannot be admitted under Rule 608.
May I respond once again?
Let me ask you this. So this was an ex parte petition for injunctive relief. Did the court grant this restraining order?
No, Your Honor, it was dismissed. However, it is still a public record.
Okay. The reason I ask that is because if it goes towards the defendant's truthfulness or untruthfulness, and the court seemed to agree with the defendant, I don't believe it would go towards the untruthfulness of the defendant in this case. So I don't think that 608 would apply in this context. And we go back to the original, I guess we're back at square one now with 404. Is there any other reason you're offering this evidence other than to show action and conformity therewith?
Your Honor, to put it simply, we are presenting this evidence to show the fact that Cara Bassett most certainly attempted to injure Don Clark. In fact, she had intention to do so even following this event. This is found in the second page of this exhibit, as it identifies that Don Clark was under the impression that Cara Bassett was going to kill him, Your Honor.
Your Honor, may I respond?
Yes.
Mr. Atherton just argued that they are using this document to show that Ms. Bassett was violent towards Don Clark, and specifically linked it to Don Clark's murder on August 18, 2017. Your Honor, that's the precise definition of character evidence. Opposing counsel is using this evidence to prove conduct in conformity with the prior bad act.
May I make a final response, Your Honor?
Yes.
We would like to direct the court's attention to the specific language in Rule 405, Section B. It identifies that it is in correlation with a charge or claim. For clarification, Your Honor, we are charging the defendant with murder with malice aforethought. And therefore, Your Honor, this evidence most certainly goes to that very fact. And therefore, it falls under Rule 405, Section B.
May I respond?
No need to. Character is not, as a matter of law, an essential element to a murder charge. Therefore, 405B does not apply here. I tend to agree with the defense in that it seems this is being offered for action and conformity therewith. Therefore, I am going to sustain the objection on that basis and exclude Exhibit 34 pending any other evidentiary objections.
Yes, Your Honor.
Yes, Your Honor.
Agent, based upon the examination, or rather the investigation that you've conducted, do you believe that Don Clark is still alive?
No, sir. We found no evidence to indicate that at this point, Mr. Clark is still alive. The only evidence we found suggested that the defendant had killed him.
And based purely upon your observations, please provide an additional elaboration as to why you think so.
Now, that's because the GPS records show that that van left the elephant park and went to the Big Gum Swamp. That elephant tranquilizer is missing, so we believe that the defendant injected that into Mr. Clark. And then because of the algae on her boots, we know that she was the one driving that van and that she'd been in the Big Gum Swamp and that Mr. Clark's hair was in the back of that van. So we believe that all indicates to us that she took Mr. Clark to that swamp and dumped his body there after killing him.
Thank you, Agent. That's all, Your Honor.
All right, thank you, counsel. Defense and Miss, is it Getachew? I'm sorry.
It's just Getachew.
Getachew. Okay. Ms. Getachew, cross-examination?
Yes, Your Honor. May I proceed, Your Honor?
Yes, you may.
Agent Branham, I want to talk about the lack of evidence you have against Kara Bass. You never found Don Clark's body, did you?
No, we didn't. We believe that it was most likely consumed by alligators.
So just to be clear, in your murder case, you couldn't even locate the murder victim.
That's true. There was no body.
So you never conducted an autopsy?
And no, without a body, we were not able to conduct an autopsy.
Without an autopsy, you can't confirm that it was elephant tranquilizer that killed Don Clark.
No, but that's what we believe because of the missing elephant tranquilizer.
I want to talk about that missing elephant tranquilizer. You never did find the syringe of elephant tranquilizer you believe was used to kill Don Clark, right?
That's correct. It was never found.
So in your murder case, you couldn't even locate the murder weapon.
No, that was what was suspicious to us, was that that was missing.
Now you searched Miss Bassett's home, right?
That's correct.
In Miss Bassett's house, you found nothing.
We didn't find anything of interest, no.
And you searched the greater Tallahassee Elephant Park for signs of violence.
That's true.
Again, you found nothing.
Well, no. Injecting someone with an elephant tranquilizer wouldn't exactly be violent.
Now you testified on direct that you believe Miss Bassett dumped Don Clark's body at Big Gum Swamp, is that right?
That's correct.
But you searched that swamp.
We did.
You found nothing significant.
Right, we believe the evidence was well disposed of.
Now I want to talk about the evidence you did collect. You testified that you found some algae on Miss Bassett's boots that matched algae from Big Gum Swamp, right?
That's correct, yes.
You're aware that Miss Bassett lives in Florida?
Yes, I am aware of that.
You'll agree with me that Florida is surrounded by ocean.
It is surrounded by ocean, yes.
Florida has thousands of lakes.
It does.
Florida has over 1,000 swamps.
Objection, Your Honor, and I apologize. This was intended to be the prior question. However, I did not unmute my mic.
Yeah, I thought I saw your mouth moving, but I didn't hear anything. So what's your objection to, counsel?
Your Honor, this falls under Rule 402 as well as Rule 403, specifically in relation to the existence of lakes in Florida. Your Honor, we're not here about lakes, and in fact, we're not here about any other lake with the exception of the Big Gum Swamp.
Counsel, why is this relevant?
Yes, Your Honor. In order for evidence to be excluded as irrelevant under Rule 401, the bar is incredibly low. Any evidence that can determine a material fact can be deemed as relevant. And Your Honor, I'm presenting this evidence to attack the prosecution's evidence that the algae on Miss Bassett's boots matched algae on the swamp. And that means that algae could only have been found at Big Gum Swamp. I'm using this evidence to show that there are plenty of other places in Florida that Miss Bassett could have picked up this algae.
Response?
Yes, Your Honor. While I do appreciate opposing counsel's response to my 402 objection, I don't believe they've addressed the 403. Because simply put, Your Honor, the misleading of the jury and that aspect of this testimony does not simply outweigh, but substantially outweighs any sort of probative value.
So is it your contention that evidence that there are other swamps and places that it violates 403 because evidence of there being other swamps and places could be misleading to the jury?
Yes, Your Honor. Specifically, due to the irrelevance of this testimony, it can therefore, and it will therefore, mislead the jury.
Okay. Response to 403?
Yes, Your Honor. First of all, you can't object and say that evidence is irrelevant, and then also say it's more prejudicial than probative, because then you're admitting that it does have probative value. Furthermore, under Rule 403, in order for evidence to be excluded, the probative value must be substantially outweighed by its risk of unfair prejudice. And the risk of this could unfairly prejudice or mislead the jury is not high enough in order for this evidence to be kept out.
If I may more elaborate, Your Honor.
Yes, last shot, then I'll rule.
Yes, Your Honor. Specifically, the reason why I just mentioned the irrelevance of this testimony is because the court has yet to rule on the 402 objection, and so I was simply deciphering the contrast of the two. However, Your Honor, once again, my argument proceeds in that in the event this is admissible, in the event this is relevant, it will mislead the jury. But that's just assuming it's relevant, Your Honor, because this simply is not relevant.
I appreciate both of your arguments. Given the low bar of relevance, and I don't believe this testimony is substantially more prejudicial than what little probative value it may have, I'm inclined to overrule the objection at this point. If we keep going down this road, though, feel free to renew your objection, but for now it's overruled.
Thank you, Your Honor.
I'll ask the question again, Agent Brown. Florida has over 1,000 swamps, right?
I'm sure it does, yes.
You'll agree with me. Algae can grow in an ocean or a lake or a swamp, right?
It can, yes.
Now I want to talk about the evidence you overlooked in your investigation. You received a letter from Don Clark's attorney, right?
We did, yes. I wouldn't say we overlooked any evidence relating to that, though.
Ms. Walker, could you show the jury what's been pre-admitted as Exhibit 4? In this letter, you learned some information about Don Clark's ex-wife, Lisa Clark, right?
I did, yes.
You learned that she was prone to outbursts and threats to Don Clark, right?
That's what Mr. Clark's attorney said, yes.
You learned that Don Clark was considering a restraining order against her.
That is what this document says.
But you never interviewed Lisa Clark.
No, I never did. We never found anything that pointed to her having been at the scene of the crime.
In fact, she refused to cooperate with the police.
She did refuse to cooperate, but there was no evidence to prove that she had any involvement in this crime.
Lisa Clark told you that Don Clark deserved to die.
Yes, that is what she said.
Now, you looked at Don Clark's phone records, right?
We did examine those in our investigation, that's correct.
Ms. Walker, could you show the jury what's been pre-admitted as Exhibit 21? Now, in these phone records, you didn't see any threatening or violent texts or calls from Ms. Bassett on the night of the murder, right?
No, we didn't see any physical proof of her threats. That was mostly circumstantial evidence.
I'm glad you admitted it was circumstantial evidence. Now, Agent Branham, what you did see was a 52-minute phone call with the Costa Rican number, right?
That is what we saw, that's correct.
But you never found out who this person was?
We never found out who the call was from because there wasn't any evidence to suggest they played a role in this crime. That was all the defendant.
You never found out why this person was speaking to Don Clark just a few hours before he disappeared, right?
No, it wasn't relevant. Again, there was no forensic evidence.
Thank you, Your Honor. No further questions.
Thank you, counsel. I'm not sure if there's any time for redirect, but redirect examination?
May I just ask one question, Your Honor?
Per Mr. Bernstein's instructions right at the start of trial, if time's expired, my hands are tied, unfortunately.
Yes, I understand.
Okay. So with that, does the prosecution have anything further?
No additional evidence, Your Honor.
Okay. In that case, we will shift gears and go to the defense case in chief. Ms. Getachew, will you be calling ending witnesses today?
Yes, Your Honor. The defense would like to call Joe Young to the stand.
Okay.
Good afternoon. Could you please introduce yourself to the members of the jury?
Good afternoon. My name is Joe Young.
What do you do for a living?
Well, I like to say that I'm the world's best TV show producer. I produce TV shows like reality TV shows and documentaries.
Well, Mr. Young, if you're a TV producer, what are you doing in testifying in court today?
Well, I know the people that are involved in this trial. The deceased, disappeared, Don Clark and Miss Bissett.
Now, we'll get into the details of what happened the day Don Clark disappeared in a moment. But first, I want to get to know a little bit more about your relationship to Miss Bassett. When did the two of you first come into contact?
Well, back in 2015, Miss Bissett called me that she wanted to work on this TV show. We were going to call it Elephant Queen.
What did your job as her TV producer involve?
Once again, Your Honor, I apologize. I accidentally muted my mic, but the prosecution would object to Cara Bassett's statements in relation to the hiring of Joe Young.
Okay, if you could refresh the court's memory as to what those statements were.
Are you asking the prosecution?
Sure, which statements are you objecting to as hearsay?
Specifically in reference to the fact that Cara Bassett asked Joe Young to come and be a filmmaker for her to document her essentially life.
May I respond, Your Honor?
Yes.
Ms. Bassett asking Joe Young to be your TV producer, that's not a statement, it's a question. Therefore, it's not hearsay under Rule 801. It doesn't elicit any truth since it's a question.
What truth is being asserted through that question, counsel?
Rather, Your Honor, we would simply contest that the statement, or rather the question, as Ms. Getachew mentioned, is most certainly an assertion. That Cara Bassett wanted her life to be produced to the entirety of the social media. Therefore, we do not believe that is necessary, which is why we would also like to object under Rule 402.
May I respond, Your Honor?
Okay, yeah. Let's go to 402, I guess, first, because if it can't clear relevance, all the other stuff is, doesn't matter. So why is this relevant, first off?
Yes, Your Honor. In order for this evidence to be excluded under Rule 402, the bar is incredibly low for relevance. Your Honor, the jury needs to know this information to know why Joe Young even knew Cara Bassett and to know why his testimony is relevant in court today.
Yeah, I'm sorry, counsel. I tend to agree with you. I think relevance has been cleared in this case. So to the argument that the question includes an assertion that Cara Bassett wanted her life documented, what say you to that?
Yes, Your Honor. Oh, pardon me, Your Honor.
Were you referring to opposing counsel or are you referring to defense counsel?
I was referring to you. How do you respond to the argument that the question included the assertion that Cara Bassett wanted her life to be documented, which I understand is the government's position? Is that right?
That is correct, Your Honor.
Okay. So what's the defense's response to that?
Your Honor, Ms. Bassett didn't say in this statement, I want you to document my life. She said a question, can you document my life, for example? And under Rule 801, questions are not statements because questions don't elicit any truth.
Yes, briefly, and then I'll rule.
Opposing counsel mentioned that inquiries are not statements. However, Your Honor, under the hearsay rule, assertions are hearsay. And Your Honor, by Cara Bassett presenting the inquiry as to the fact that she wanted her life to be documented, I'm paraphrasing, of course, that is therefore hearsay.
So two things. First off, questions can have inherent truth value. For instance, if you ask the question, why are you stabbing me with that knife? There is a truth being asserted that someone is being stabbed with a knife. So just because it's a question doesn't make it per se not hearsay. However, in this case, I believe that any assertion that could be interpreted from the question would go towards Cara Bassett's state of mind, in which case it would be admissible and not hearsay or fall under one of the hearsay exceptions. So I'm going to overrule the objection.
Yes, Your Honor. Thank you.
I'll ask the question again. When was the first time you and Cara Bassett came into contact?
Well, like I just said, we came into first contact in 2015, where she gave me a call and asked if I produced this TV show for it. We were going to call it Elephant Queen.
What did your job as her TV producer involve?
Well, I had a pretty strict work schedule. I was 5 days a week. I was filming the elephants. I was filming the employees. I was filming Donnie and Miss Cara Bassett. so I was doing a lot of work for them.
How long did you work for Kara Bassett?
For about 3 years, from August 2015 to September 2018.
In those 3 years you were filming, how much footage do you have?
We had a large 2,000 hours worth of footage.
Did you ever give this footage to the FBI?
Well, they never questioned me on it, so I never did get to give them the footage.
Would you have been willing to give them this footage?
Look, I'm not a biased man. I would have more than loved to give them this footage. They just never asked.
In the 3 years you spent working for Miss Bassett, would you say you got to know her well?
I did. It's a part of the job to get to know the people that I'm filming, and it's going to be in my show pretty well.
Did you get to know Don Clark well as well?
You mean Donnie? I got to know Donnie pretty well, too. I filmed him just as much as I filmed Kara.
In the 3 years you worked for them, did you ever witness Miss Bassett or Don Clark get violent with each other?
No, they weren't really the violent couple. They were pretty uptight, lovey-dovey, like, a pretty nice couple.
Did you ever witness Miss Bassett threaten to hurt Don Clark?
No, that's not who Miss Bassett is. She never threatened to hurt Don.
Objection, Your Honor. Improper opinion. May I be heard under Rule 201, Section E?
201?
Yes, Your Honor. 201, Section E.
Sure.
Your Honor, we would contest that opposing counsels presenting, or rather the witness mentioning that Kara Bassett would never hurt Don Clark. That is not admissible. In the event that Ms. Young, or rather Mr. Young, would like to simply identify the fact that he did not see Kara Bassett injure Don Clark on the day in question, we would have no objection. But with opposing counsel presenting the inquiry as to whether Kara Bassett would ever hurt Don Clark, that is most certainly not admissible.
Counsel, I'm a little confused as to the basis of the objection. I've got 201E pulled up here, and it pertains to opportunities to be heard during judicial notice, which I don't think we're talking about at all here.
Yes, Your Honor, if I may clarify, the reason why I presented Rule 201E is because I was requesting an opportunity to be heard.
Oh, okay. So what is the evidentiary basis for the objection? What rule are you referring me to on this particular objection?
That it is an improper opinion.
Okay. Understood. Response to the improper opinion objection?
Yes, Your Honor. This witness testified that because he never witnessed Miss Bassett ever threatened to hurt Don Clark, that he didn't believe that she ever could have. This is rationally based on this witness's perception. He offered this opinion based off of what he witnessed of the relationship between Miss Clark and Miss Bassett and Don Clark. Therefore, this is admissible as it's based on his rationally based perception under Rule 701.
May I respond?
Yes.
Your Honor, to put it simply, Joe Young, if I be respectful, Joe Young is not God. Therefore, he cannot provide an opinion as to whether Kara Bassett would ever act in a certain way. In the event that opposing counsel would like to not utilize the word never or ever, I'd be happy to refrain from objecting.
Response?
Yes, Your Honor. Again, I'd like to stress that this opinion the witness gave was rationally based on his own perception. Under Rule 701, witnesses can offer opinions if they're rationally based on their perception. And this witness offered this opinion based off of what he witnessed of the relationship between Miss Bassett and Don Clark.
Okay. It's certainly an opinion. I don't think it's one that's based on, or could be based on, the perceptions of the witness. So on that basis, I'm inclined to sustain the objection and exclude, I guess, the end of the answer, which was Kara Bassett would never do something like this. So I'm going to strike that portion of the witness's response and keep the rest.
Yes,
Thank you, Your Honor.
I'll re-ask the question, Mr. Young. Did you ever specifically witness Miss Bassett threaten to hurt Don Clark?
No, I never witnessed her hurting Don Clark.
Now I want to ask you about what happened the day Don Clark disappeared. Were you at the park on August 18th, 2017?
I was conducting my usual business.
Did you see Don Clark on that day?
I did, yes, ma'am.
Did you speak to Don Clark?
I did. Me and Donnie had a conversation that day. I was kind of talking to him about some of the film I was producing. And during this conversation, I remember Don looked down at the phone, and his face got real pale for some reason. And he said he had to go.
Objection, Your Honor, once again under Rule 802 hearsay. And I actually have two specific references, if I may be heard.
Okay. Which statements specifically are you objecting to?
Two, Your Honor, specifically that Don Clark was replying in a certain way and then he looked down at his phone and said that he had to leave. But in addition to that, the fact, or rather the ideation that Don Clark's face went white. Your Honor, under Rule 801, Section C, it identifies that communication, or rather hearsay, can be nonverbal. And we would most definitely assert that Don Clark was providing this evidence by way of utilizing an assertion.
Response to that?
Yes, Your Honor. As to the statement of Don Clark's face going white, that's not a statement under Rule 801. We are not saying that this was a verbal statement or Don Clark said anything when his face went white. This witness was merely observing something that he saw on Don Clark's facial expression. Furthermore, Your Honor, as to the statement that Don Clark had to leave, this is a statement of intent under 8033, that Don Clark was intending to leave at that moment.
May I respond?
Yes.
Yes. First of all, if I may direct opposing counsel's attention to Rule 801, Section C. It identifies the definition of hearsay and attributes to the fact that hearsay can in fact be non-verbal conduct. The prosecution would contest that by this witness identifying the fact that Don Clark's face went white, he was intending it as an assertion for a proposed inquiry.
So, counsel, by that argument, it suggests that an individual has control over whether or not they can turn their own face white. Would you agree with me if someone's face turned white and it was involuntary, it would not be a statement?
The prosecution would contest that the phrase, her face, or rather his face went white, does not simply attribute, or rather specifically in reference to the whiteness of his face. Your Honor, that would also apply to perhaps any sort of facial expressions that Mr. Clark could have been exemplified.
May I respond, Your Honor?
Sure.
I agree that nonverbal action can be a statement under Rule 801. However, it is not in this case. Just like you said, Don Clark didn't voluntarily have his face go white so that he could tell something to Joe Young. That was an involuntary facial expression that this witness was just observing.
Yeah, I'm inclined to agree, and I'm inclined to agree that 8033 is the exception here. I'm going to overrule the objection.
Yes, Your Honor.
Yes, Your Honor. Mr. Young, I want to talk about whether the government's story today makes sense. Are you aware that the FBI believes Miss Bassett killed her husband?
Yes, I'm surprisingly aware of that.
Are you aware that the FBI believes Miss Bassett injected him with an elephant tranquilizer?
Yeah, just as surprised about that one too, ma'am.
Mr. Young, how tall exactly is Kara Bassett?
Well, I wouldn't say tall. She's a short 5'4".
How tall is Don Clark?
Now, that's tall. He was about 6'5".
Would you say that Don Clark was a lot larger than Kara Bassett?
Would I say? No, I know he was a lot larger than Miss Bassett.
Now I want to talk about who actually could have done this. Earlier, you testified that you never witnessed Miss Bassett threaten to hurt Don Clark. Do you know of anyone who had?
Yes, ma'am, I do. It was his ex-wife, Lisa Clark.
How did Lisa Clark threaten him?
Well, look, one day they were getting into this huge fight, and I remember Miss Clark said something on the lines of, "I'll wipe you off the face of the earth. You'll be sorry."
Do you know of anyone else who may have wanted to hurt Don Clark?
Well, I also knew that Don had some business going on in Costa Rica with some folks. He didn't talk too much about it, though.
Do you know if Don Clark ever traveled to Costa Rica?
Well, being as wealthy as he was, he did quite a lot of traveling to Costa Rica.
When he went to Costa Rica, did Don Clark ever take Miss Bassett with him?
No, ma'am, not once to my knowledge.
Did Don Clark go to Costa Rica with anyone else you know?
Once again, no, ma'am, not to my knowledge.
Now, Mr. Young, I have to ask, do you know what could have happened to Don Clark?
I don't have a clue in this world. There seems to be too many possibilities here, so I don't know.
Thank you, Mr. Young. Thank you, Your Honor. I have no further questions.
Now, of course, it's me who's muted talking. Thank you, Ms. Getachew. Mr. Atherton, cross-examination.
Yes, Your Honor. Good evening, Mr. Young. My name is Paul Atherton, and I'll be asking you a few questions today.
Alrighty.
Now, you are fairly well acquainted with the defendant, correct?
Yes, I like to say I know Miss Bissett pretty well.
Right. She hired you in the year 2015, correct?
Yes, she did hire me.
Right, and Miss Bassett hired you because she wanted to document essentially her life to social media.
Yes, that and her love for those elephants. Yes, sir.
Right, absolutely. Now, Miss Bassett paid you $5,000 a month, is that correct?
She did. What I do is pricey stuff, so she had to pay quite a lot.
Yes, sir, and if you don't mind, I'd definitely like to see your work one day. But for now, I'd like to discuss your specific instance in reference to August 18th. But
All
before
right.
that, you are aware of Don Clark, correct?
I was. Yes, sir.
You were?
I'm sorry, I must not have heard your question clear. You asked if I was aware of Don Clark?
Pardon me, Mr. Young, I'll move on. So for clarification, you are aware of the fact that Don Clark and Cara Bassett were married, correct?
Yes, I was aware of that fact.
Right. Did you see, or rather, you saw Don Clark the day of August 18th, correct?
I did. Yes, sir.
Yes, sir. You had a conversation with Mr. Clark August 18th at 6 p.m., correct?
Yeah, I did.
I believe you mentioned it in your direct examination, and I believe opposing counsel can further provide that evidence if they need be. But for clarification, you did not see Don Clark leave the park after that conversation. Is that correct?
No, sir, I did not see Donnie leave the park.
Now, you would agree with me that Cara Bassett and Don Clark did have their occasional fight.
They had a few occasional fights, but nothing too serious now.
Right. Now, I'd specifically like to reference the mention in your affidavit. You would agree with me that Cara Bassett seemingly threw a vase at Don Clark, correct?
She threw a vase. Yes, she did.
And you did, in fact, document this, right? Or rather,
I did. As a producer, I'm supposed to document this kind of stuff. Everything.
Absolutely, sir. But subsequently, you would agree with me that Cara Bassett told you to take away the footage.
She did want me to delete the footage, but I probably would have deleted it myself. I didn't think it was going to hit the audience that well.
Right, absolutely. But you would agree with me that the reason why Cara Bassett didn't want this information to be produced was because it probably would have framed her public image, correct?
Well, it probably would have. I don't know if it really would, though. That's just what she told me, sir.
All right. Well, you would agree with me that going back to your conversation with Don Clark, you left from Mexico subsequently, right?
I did. I had to take me a bit of a vacation.
Yes, sir. Absolutely. Now, you would agree with me that you returned August 26th of 2017, correct?
Yeah, that's correct, sir.
Now, once you returned, you realized that there was an FBI investigation occurring, correct?
There was an FBI investigation occurring at that time, yes, sir.
You would agree with me that you were not able to discover the body of Don Clark.
To my understanding, yes.
You would agree with me that Cara Bassett was never able to discover the body of Don Clark.
Unfortunately, she never got to see her husband again, sir.
Right, but you would agree with me that Cara Bassett made no attempt to contact her husband following his disappearance.
Well, I don't know what she did really during the time I was in Mexico.
Objection, Your Honor. Non-responsive.
Response?
Yes, Your Honor. The witness is entitled to a brief explanation after opposing counsel asks him the question.
Yeah,
Yeah.
I think we are only about 3 words into the answer, so I'm not sure if we were about to hear a response. If you could ask the question again, and Mr. Young, if you could answer the question.
Yes, Your Honor.
Yes, Your Honor. I'll restate the question. Yes or no? You were not able to discover the body of Don Clark.
I wasn't, no, sir.
Yes or no? Cara Bassett did not contact Don Clark following the day of August 18th.
Well, sir, I don't fully agree with what you're soliciting, sir.
All right. Well, I'd like not to talk about what I'm eliciting. I'd just like to talk about your answer. Yes or no?
I don't
Cara
fully agree with those facts, no, sir.
did not call, did not text Don Clark following the night of August 18th.
I don't know what happened when I was in Mexico, but other than that, no, sir.
All right. Well, regardless, you would agree with me that you conducted an interview with Miss Bassett.
I did, yes, sir, as part of the TV show.
In fact, you made over 14 interviews.
That's correct, yes, sir.
And you provided them to be referenced in court today.
Yes, sir. You get to see a bit of my work if I say so.
Absolutely, I'd love to. And you would agree with me that you do customarily make these interviews within your occupation, yes?
Yes, we do make these for the TV show specifically.
And after conducting this interview, you would agree with me that you kept this within the customary occupation, or rather, line of your occupation, right?
I kept it for the purposes of the TV show, yes.
Yes, Your Honor. At this time, the prosecution would like to show an image of Exhibit 38. However, before we do so, we'd like to enter it into evidence.
Okay. Any objection to Exhibit 38?
No objections, Your Honor.
Okay. 38's admitted.
Thank you, Your Honor.
People look at me and they think I'm sweet and nice. Go on. Keep underestimating me. I will lobby senators. I will protest big businesses. I will get in your face. I will take people to their grave if I have to. I will do anything to protect these elephants.
Were you able to hear that video well, Agent, or rather, Mr. Young?
I did, yes, sir. It's a wonderful piece of art right there.
Well, I would most certainly agree with you. But regardless, you would agree with me that about a year after the disappearance of Dawn Clark, you went to Costa Rica, right?
I did go to Costa Rica, yes, sir.
To investigate Mr. Clark's property.
I did look into it, yes, sir.
But you would agree with me that you discovered no signs, or rather, you just did not encounter Dawn Clark, correct?
I never encountered Mr. Clark, no, sir.
Oh, well, for my final question, Mr. Young, I'd like you to just answer with a true or false, all right? True or false? You cannot present a body if the body has been eaten.
I would have to disagree. I'm sure there might be some remains, sir.
Thank you, Mr. Young. But once again, I'd like to ask specifically true or false. When an individual is eaten, you cannot see their body.
We'll say false on that one.
All right, well, regardless, Your Honor, that is all.
Okay. Thank you, counsel. Is there any redirect?
No redirect, Your Honor. May this witness step down?
Yes. Mr. Young, you're excused. Thank you for your time.
Thank you.
Does the defense have any other witnesses today?
No, Your Honor. The defense rests.
Okay. In that case, well, I guess I should ask first if the parties want to take a couple of minutes before closing arguments start. I guess a couple minutes are already built into the process because the jurors will be filling out their ballots for the witnesses at this point. But do you think you need more than a couple of minutes?
If possible, just a couple of minutes would be lovely, Your Honor.
Okay,
Yes, Your
great.
Honor. Agrees.
All right, so those couple of minutes we'll take now, and that'll be an opportunity for the jurors to please fill out the witness portion of your ballot. And in addition to that, if the jurors could please switch back over to speaker view for closing arguments. right, we'll take about another minute or so. All right, Mr. Atherton, are you ready to proceed with closing arguments?
Yes, Your Honor. However, before I commence, the prosecution would request up to 2 minutes for rebuttal time.
Of course.
With that, we are ready.
All right, we'll hear from you now.
She chose her passions over her partnerships. You have heard those words from the prosecution multiple times throughout this trial. We have proven, and you have heard a lot of things. You have heard, and we have proven that Cara Bassett was known to lash out at Don Clark. You have heard, and we have proven that Cara Bassett was one of the few people to have had access to the supply facility. You have heard, and we have proven there was one tranquilizer missing from that supply facility. You have heard, and we have proven, that Cara Bassett's Chevrolet Express van was driven to the Big Gum Swamp the night of August 18th. You have heard, and we have proven, that 6 of Don Clark's hairs were found in the lower back interior of the van. You have heard, and we have proven, that Cara Bassett's own boots had the same algae as was discovered at the Big Gum Swamp. You have heard, and we have proven, there was also a wheelchair found near Cara Bassett that also had the same algae as was discovered at the Big Gum Swamp. You have heard, and we have proven, that Cara Bassett made no immediate attempts to discover the location of her husband following his disappearance. You have heard, and we have proved, that Cara Bassett waited 7 days to alert the police of said disappearance of her life partner. You have heard, and we have proven a lot of things throughout this trial. But let's talk about what you have heard. You haven't heard one person identify that they saw Don Clark following the night of August 18th. You haven't heard a slightest bit of grief from the defendant. You have not heard one reasonable alternative from the defendant's counsel. Members of the jury, despite those facts, the prosecution, or rather the defense, claimed that Don Clark relocated to Costa Rica the night of August 18th. But let's remember what Agent Braun mentioned in his direct examination. He identified the fact that Don Clark says the airplane was located stationary in an airport hangar. Therefore, it could not have been in Costa Rica with Don Clark. Additionally, they inferred that there could have been a third party involved in the murder of Don Clark. But members of the jury, in the event Don Clark went missing, the entirety of his assets would be directly transferred to Cara Bassett. This was not a coincidence. This was a plot for power, and this was a plot for control. There has been a lot of dispute throughout this trial. But the fact of the matter is, there is only one person who does not want Don Clark here in court today. And that is the defendant. Members of the jury, why? Cui bono? Who benefits? Cara Bassett benefits. Don Clark will never get to innovate his business. He'll never get to see his children grow up. He will never get to see the birth of his own grandchildren. But why? The answer to that question is found in one woman's passions, and one woman's decision to choose those passions over her life partner. Think about the one. 1 week, $1 million. One missing tranquilizer. These facts lead to one inescapable conclusion. But once again, we are the prosecution. We have the burden of proof. We have to show to you beyond a reasonable doubt that Dawn Clark, A, was killed by Cara Bassett, and B, that she did so with malice aforethought. We have built our case piece by piece, exhibit by exhibit, testimony by testimony, until you were left with this overwhelming tower of circumstantial evidence, showing the defendant's desire for control. And she got it. But at what cost? It was at the cost of an innocent man's life. We ask that you find the defendant guilty.
Thank you, Mr. Atherton. Ms. Getachew, the court is with you for defense closing argument.
Yes, Your Honor. May it please the court, members of the jury. The government overlooked the truth. I agree with Mr. Atherton. I agree that Miss Bassett inherited some money after her husband died. I agree that Miss Bassett argued with her husband. And I agree that Dawn Clark didn't just disappear into thin air. But I disagree that Miss Bassett chose her passions over her life partner. I disagree that Miss Bassett killed her life partner, Dawn Clark. The truth is, Cara Bassett is not a murderer, but the government overlooked the truth. And yet it's Cara Bassett who's on trial today, because the government charged her with the murder of Dawn Clark. Now, Mr. Atherton got up here and talked a lot about what the defense didn't show you today. But I want to be clear. The defense has no burden of proof in today's case. We didn't have to call a single witness to the stand. We didn't have to show you a single piece of evidence. And members of the jury, I didn't have to state a single word onto the record, because that job belongs to the government. The government holds the burden of proof. Throughout this trial, they had to prove to you that Miss Bassett killed Dawn Clark and she intended to kill her. They had to prove this to you beyond all reasonable doubt. This is the highest burden of our legal system. To meet this burden, the government can't leave any questions unanswered, any holes in their case, or a single stone unturned. And if they haven't met this burden, then Miss Bassett cannot be found guilty today. Because Miss Bassett has what's called a presumption of innocence. This presumption is the foundation of our legal system. In our country, all defendants are innocent until proven guilty. And Miss Bassett is innocent until the government is proven beyond all reasonable doubt that she is guilty. And they haven't met this burden in court today, because the evidence showed you that the government overlooked the truth. Let's talk about what the government overlooked. You heard from Joe Young today, a TV producer who worked with Miss Bassett and Dawn Clark every day for 3 years. He told you that Dawn Clark had some suspicious and secretive business dealings in Costa Rica. But you learned today the FBI barely asked Joe Young any questions, because the FBI, they overlooked the truth. But you saw the truth in Dawn Clark and Miss Bassett's phone records. You didn't see a single threatening or suspicious text or call from Miss Bassett planning the murder. Instead, you saw a 52-minute phone call from a Costa Rican number. But just like Agent Branham admitted to on the stand today, the FBI never found out who this person was or why they were calling. But there's another suspect that the government overlooked. Someone who hated Dawn Clark. Someone who wanted money from Dawn Clark. Someone who repeatedly threatened Dawn Clark. That someone was his ex-wife, Lisa Clark. You saw in a letter from Dawn Clark's lawyer that Dawn Clark was considering a restraining order against her. Agent Brandon admitted to you on the stand today that she said Dawn Clark deserved to die. And yet the FBI never interviewed Lisa Clark. The FBI never looked at Lisa Clark's cell phone records. The FBI never searched Lisa Clark's properties. No, because the government overlooked truth. Now, Mr. Atherton got up here and told you that Miss Bassett chose her passions over her part. He told you that Miss Bassett repeatedly threatened Don Clark. But the lead investigator of this case, Agent Branham, told you on the stand today that they have no definitive proof of this. Agent Branham got on the stand and told you today that all the evidence they have that Miss Bassett threatened Don Clark, he told you that evidence was circumstantial. And I wholeheartedly agree. And members of the jury, circumstantial is not beyond all reasonable doubt. The government overlooked the truth. Mr. Atherton also tried to convince you that Miss Bassett was at the swamp on the night of the murder because the algae on her boots matched algae from the swamp. But just like you heard in court today, that algae could have come from anywhere in Florida. The truth is, the government has no physical evidence directly linking Miss Bassett to this crime. And I was asking Agent Branham some questions earlier today. I noticed that he kept agreeing to the same 3 words. I found nothing. Agent Branham searched Miss Bassett's house. He found nothing. Agent Branham searched the elephant park for signs of violence. He found nothing. Agent Branham searched Big Gum Swamp, and again, he found nothing. And in fact, you learned today that they never even found Don Clark's body. Can you believe that? The government wants you to believe that Miss Bassett killed Don Clark with an elephant tranquilizer, and they don't even have a body. They don't even have an autopsy. They want you to believe that it's more likely that Don Clark was eaten by an alligator. Members of the jury, the government overlooked the truth. The government's entire case rests on the careless investigation of Agent Branham. The government wants you to convict someone for murder with no murder victim, no murder weapon, no physical evidence, no surveillance, no eyewitnesses, no threatening texts, calls, or emails, and no proof that Miss Bassett even planned this crime. Nothing. All the government has shown you in court today has been leaps of logic, assumptions, and guesses as to what could have happened to Don Clark. This means they haven't met their burden of proof in court today. Because in this country, Miss Bassett is innocent, so the government has proven beyond all reasonable doubt that she is guilty. And right now, at the end of Miss Bassett's trial, she is just as innocent as she was in the beginning, because the government overlooked the truth. Find Kara Bassett not guilty. Thank you.
Thank you, Ms. Getachew. Rebuttal, Mr. Atherton?
Yes, Your Honor.
There was one person who overlooked something throughout this trial. Kara Bassett overlooked the meaning of a life partner. Not one other person had the means, the tranquilizer. Not one other person had the motive, the $8.2 million. Not one other person had so much built-up anger that she unleashed it upon her husband. Members of the jury, Miss Getachew, the lovely Miss Getachew, made attempts throughout this trial. Piece by piece, she attempted to detract from our case in chief. But the fact of the matter is, members of the jury, despite her noble attempts, the tower of evidence stands tall. It's because the tower of evidence stands tall, we need you to consider these words. You cannot present a body when the body has been eaten. We ask that you find the defendant guilty. Thank you.
Thank you, Mr. Atherton. Okay, so now the judges should complete their ballots and click submit. And I'll ask everyone to stay on afterwards